additional 360 days for a total of 540 days. So what does that mean? That's like a year and a half of time when you can continue to work, and you don't have to worry about your employer being upset that you don't have work authorization, because you will be able to show that you do have this automatic extension. Something that's important to remember is that this applies specifically to certain categories, such as people who have pending applications based on seeking asylum, having received asylum, refugees, VAWA self-petitioners. It doesn't apply to every single category. So you want to make sure that when you are applying to renew the work authorization, that it fits your category, that you are one of the people who benefit from this extension. So that's really great news. So some of you are probably wondering, who does this apply to? Is it just starting now? So here are the rules for when it's going to apply and who it's going to apply to. If you filed your work authorization renewal application before May 4th, and it has already been more than 6 months, then this is an option for you. It's going to apply to you. If you applied before May 4th and you still have a couple months left from the 6 months, the extension is also going to apply to you, and it's going to apply to anybody who's applying for a work authorization renewal between May 4th, so as of a few days ago, last week, and October 26, 2023. So this is USCIS saying that basically this year and next year they're going to take some time to get back to people with their work authorizations, and so in recognition of that, they're going to help you out with your work situation where you're not in a state where you're unauthorized to work and you can't prove that to your employer. Just keep in mind that according to the regulations, the information that has come out, anyone who applies for a work authorization renewal application after October 26th of 2023 next year, it is going to revert back to the automatic 6-month extension. So these are the guidelines right now. Of course, this could change. They may extend that date beyond next year in October. We don't know. With many things in immigration, especially with USCIS, the law is constantly changing, and they make changes to take into consideration what's going on, to reflect how long things are actually taking. So just keep that in mind. But this is really great news, and especially something for those of you who are concerned about being out of work. All right, so along those lines, another development is that for people who are filing asylum applications, before, people didn't have to pay anything for an asylum application, including an $85 biometrics fee. But under the last administration, they started implementing a rule requiring people to pay $85 for the biometrics fee. So this fee you will no longer have to pay, and this is great news. So when you apply, you will no longer have to pay the $85. Okay, perfect. So yes, just to clarify, when you file for asylum, you are eligible to file for a work authorization, and normally you don't have to pay a fee. So people were being required to pay the $85 biometrics fee. Now you will file for asylum and the work authorization once you met the requirements, and you will not have to pay the $85 fee. Along those lines, the other important update is that now we're back to people being eligible to apply for work authorization after 6 months as opposed to waiting a year. So this was something else that came about last year or so, and now we're going back to the 6 months after which you can be eligible for the work authorization. So this is really, really great news, and it's nice to see that this change is implemented and bringing back something that was much more useful than people having to wait a whole year before they can apply for work authorization. So these are the developments related to asylum applications, people who have pending asylum, etc. Another important development to share is for people who are from Ukraine, or if you know anyone, have relatives who are nationals of Ukraine. We finally have guidelines for TPS based on being a national or citizen of Ukraine. And these are the requirements. So you can apply for TPS The registration period is started last month, April 19, up until October 19, 2023. So that's a good time period that you have. And when they first said they were going to issue TPS for citizens and nationals of Ukraine, they said it was going to start from a date in March. So a lot of people who came to the U.S. after March were not going to be eligible for TPS. But now they've changed the date to say requiring physical presence in the U.S. beginning April 19th and continuous residence from April 11th. So if you came here after April 11th, then you will be eligible to apply for TPS. And of course, there are some other requirements for TPS that you have to meet, and we have some blog posts on our website regarding TPS and the general requirements that everybody needs to meet in order to apply for TPS. So if you're from Ukraine and you know somebody who's from Ukraine, go ahead and start putting together your application for TPS. Perfect. The next thing that I want to talk about is something called the Doyle Memo. So this is something that is known by all immigration attorneys because it's something very, very important. And it's important for people to know who are in court proceedings. So I have a lot of clients telling me, oh, we heard that they're going to just dismiss all of these cases. And this is great news. So there is some misinformation about that, or not clarity about the information and exactly what that means. So what is the Doyle Memo, and how exactly is it relevant to you, and who is it relevant to? So this is relevant to people who are in immigration court and they have cases before the immigration court. According to the new regulations or the policy, people whose cases and people who are not considered a priority, their cases will be dismissed. And who is not a priority? So priority are people who aren't considered a danger, a security threat, a threat to national security, public safety, or border security. So if you're someone who doesn't really have a criminal history, who doesn't have any issues with ICE, and no terrorism background or anything like that, they're not going to consider you a priority. And by not considering your priority, what they mean by that is that they don't want to litigate your case. They don't want to go forward with your case. This could be a great thing for people whose asylum cases aren't as strong because it gives you the opportunity to stay in the United States and have your case closed. However, what we're seeing being implemented is that this policy is also being used to dismiss a lot of cases that are very strong and leaving people without any relief and without any work authorization. So there is something that you can pursue before the immigration court if your case isn't that strong, or you're not a security threat, or a threat to the national interest or public concern, or border security. And it would have been great because in the past, when people are granted prosecutorial discretion and they dismiss these cases, or admin closed them, people are allowed to work. They were allowed to get work permits. But under this new policy, you're not allowed to get work permits. So there are some people where it isn't in their best interest to have their cases dismissed. So it's very, very important that if you are somebody who has your immigration individual hearing coming up, speak with your attorney to find out if it really is in your interest to get your case dismissed, because it may not be. You don't want to necessarily be stuck in the United States without being able to work. However, if your case really, really isn't that strong and there's a possibility that you won't be granted asylum or the other type of relief that you're seeking, it may be good for you to take the chance and be able to have your case closed and stay over here, and then just take the risk of not being able to work. So this is a complex situation, and it affects every person differently because everything is case-by-case basis. So I highly recommend that if you do have a case before the immigration court, you go and you speak with your attorney and you figure out what is good for your case. The policies regarding the Doyle Memo and what have come from that also include a lot of other specific things to take into consideration, which are very nuanced, so it's best to discuss that in detail with your attorney. I'm just going to leave it to this general information. But this is something that is new, that is important, that you should ask your attorney about to find out more information. Okay, so the other update that I want to share with you today is about, again, going back to the ability to work and getting work authorizations. So USCIS is now allowing spouses of H-1B visa holders and L-1 visa holders to get to have work authorization. Previously, they had to apply for work authorization, but now they will get that incident to the principal person getting their status. What does that mean? It means that if you are the spouse of someone who has an L1 visa or an H1 visa, let me clarify. If you are the spouse of someone who has an L1 visa, as a L2 visa holder, you will get work authorization. And when you go to your interview at the consulate, they should note that on your visa with something called a S, which you will be able to show to demonstrate that you have work authorization, and you don't have to apply separately for work authorization. In regards to spouses of H-1B holders, just to clarify, it's not that they're going to automatically get the work authorization, it's that now they will be allowed to extend their work authorization, which previously they weren't allowed to do. And also spouses of E2 visa holders, they will also be allowed to work. So this is a great development for people who are getting these employment visas, because sometimes when you come here on the E2 visas and the L1 visas, your spouses are here and they have to apply for the work authorization, and they just have to wait a really, really long time before they actually get the work permit and can work. And now you don't have to worry about that. You can work. So these are just a lot of updates in immigration law. I understand that some of it may not be relevant to all of our viewers, and specific parts are relevant to other people. So what I recommend is, if you have questions about any of these things, or if there's anything else in particular that you would like to get an update on that is relevant to your case, please reach out to us or reach out to your immigration attorney, and they will go over these things in more detail. I recognize that some of what I'm discussing today is very specific, and I can't do justice to the discussion without going into a much deeper, providing much deeper background on some of these visas, etc., whatnot. But for those of you who this is relevant to, I hope this has been helpful, and please do reach out to me to discuss this if this pertains to your case. With that said, to get more updates on immigration law, you can visit the USCIS website. They're always updating their news section on latest changes that are going on. You can stay on top of the news. And of course, you can follow us on our social media to get updates as well. And if there's any big developments, we will be sharing that. So with that said, I'm going to conclude today's discussion. Thank you for joining me. If you would like more information about important immigration topics, specific visas, anything else, I invite you to go to our website and join our newsletter that we send out every month, so you can get some important and helpful information. And thank you again for joining me today. Have a great night, and I'll see you next time.